All right. U.S. Department of Transportation, Federal Railroad Administration, docket number FRA 2009-0035, RIN 2130-ACO8. Comments of the Brotherhood of Locomotive Engineers and Trainmen and the United States Transportation Union will with respect to proposed rules for conductor certification. Title 49 CFR Part 242. The comments are submitted by the Brotherhood of Locomotive Engineer and Trainmen as Division for the Rail Conference International Brotherhood Teamsters, or BLET, which is duly designed for the recognized collective bargaining representative for the craft and class of locomotive engineer employed on all Class 1 railroads in the United Transportation Union, UTU, UTU, which is duly designated recognized collective bargaining representative for the various service crafts and classes, holsters, remote control operatives, yard masters employed on all Class 1 railroads. Thus, the U2U and the Union Transportation Union United Transportation Union, the Brotherhood of Locomotive Engineer Trainmen are duly designated, recognized by the collective bargaining representatives for all training employees on all Class 1 railroads. The Brotherhood of Locomotive Engineering Trainmen and the United Transportation Union also represent operating for the employees of the numerous Class 2 and Class 3 railroads. Consequently, the proposed certification of the conductors published by the Federal Railroad Administration has a significant impact on the members. We thank the effort of the Federal Railroad Administration for the advance for the consideration of these comments. The Federal Railroad Administration noted in the preamble of the notice proposed rulemaking NPRM. The Federal Railroad Administration expects the Railroad Safety Advisory Committee (RSAC) Conductor Certification Work Group into the continued meeting after publication of the notice of proposed rulemaking to consider configuration changes in Title 49 CFR Part 240 Qualification Certification of Locomotive Engineers. We also recognize the working group reached consensus on the majority of the proposed rule. We have responded to several areas the Federal Railroad Administration has specifically requested comments, and after consideration of proposed rule contacts with our experience with the Title 49 CFR Part 240 provisions, we believe it is necessary to revisit and add comments on some of the proposed sections of this rule. We look forward to making the FRA and the future working group meetings to address these other comments submitted by the Conductor Certification National Notice proposed rulemaking docket. Alright, sub A general, section 242.1. Minimum. The Federal Railroad Administration had relied heavily on Part 240 in the development of conductor certification regulations contained and proposed by the Part 242, specifically in Section 242.1, proposed purpose and scope. The Federal Railroad Administration nearly in identical language to the contained with the Locomotive Engineering Certification Rule. Moreover, the intent of this rule is clearly provided with the same level of discretion to the railroads that they have in the implementing Part 240. Therefore, we believe it appropriate to consider how the industry has utilized the discretion of the Federal Railroad Administration entrusted to the railroads to implement additional and more stringent requirements for the certification of locomotive engineers. The Federal Railroad Administration cannot deny the railroad have repeatedly abused the discretion, and exemption of a sudden change in management philosophy on the part of the railroads is misplaced. When the Federal Railroad Administration published its original Part 240 notice of the proposed rulemaking in 1989, it noted that there's a less there's less incidental evidence to support the proposition, with the similar events receiving the signification departure treatment. Such difference exists both within and between the railroads, for the difference including decision on whether the particular person will or will not be brought before the discipline system for the given course for the conduct range punishment imposed with the same types of failure to adhere to the company rules under circumstances. 73 Federal Registration 80351, December 21st, 2008, quoting 54 Federal Federation 5089, 50890, 50899, 508 50900. December 11th, 1989. This 21-year observation was a cornerstone of the FRA historically, consequently stated commitment with the element departure treatment for the locomotive engineers, which dates all the way back to the original designation intent for the Part 240. The ID, indeed, with the Federal Railroad Administration published its first final rule in government locomotive engineering certification in 1991. It stated that railroads will have to have limited authority to deny and revoke person certification, and the Federal Railroad Administration will be responsible for resolution disputes arising with the decision to deny and resign. certificates. 56, Title 56 Federal Registration 28228229229, June 19th, 1991, emphasis added. Moreover, the FRA stated in the intent to reserve the right to exercise limited control and daily administration for the railroad program because the Federal Railroad Administration bears responsibility for the manner in which the railroad exercises their discretion, since the performance of the railroad under the rule will determine whether the safety purpose is fulfilled. The ID at 28 222 9 28 23 0. The conduct industry has not changed and one iota since the Federal Railroad Administration 21 years old observation concerning widespread departure treatment, systematic abuse for the revocation process by service of Class 1 railroad forces the FRA to significantly amend the regulatory basis for the revocation of the certification, i.e. the 5 cardinal sins in 1993, Part 240, that had been effective for even 20 years in publication of these amendments the FRA acknowledged. With respect to certain types of the operation violation of the quote rules, it does not clear distinguish series of the negligible offenses railroad believing themselves to be under regulatory mandated to take action for these offenses that might not previously have been subjected to disciplinary action have in some cases decertified employees where FRA had not anticipated such actions for these. For the most part, the railroad actions have been within the letter of the current law. However, given the experience of the Federal Railroad Administration now has been required a need to prevent further revocation of the offenses so minor that the FRA had not anticipated there being of the basis of revocation. The FRA has decided to act quickly correct on the situation. Title 58 Federal Registration 18987, emphasis added, 18987. Approximately 5 years after having to amend Part 240 the first time because of the outrageous application by the industry, the FRA published another proposed rule. See Title 63 Federal Registration 50626 through 50658, September 22nd, 1998. The time of the FRA was forced to address legitimacy for the compliance of testing circumstances under the failure of the compliance test should trigger an adverse certification consequence. The FRA expressed a concern the operational monitoring tests are used by some supervising to entrap the engineers in testing that are unfair. The Federal Railroad Administration also acknowledges that the complaints have been voiced that some tests were conducted in a manner that make it appear that the true purpose was not monitoring compliance, but more to make it appropriate difficult for the engineer to pass the ID at 50636. Indeed, the FRA was aware of quoted allegations that some supervisors have been able to get engineers decertified by hiding the fuses under the bucket and only revealing the fuses to the engineer at the point where it is impossible for the engineer to stop the train. Although the FRA has not observed such tests, the agency currently considers it an improperly conducted operational test, i.e. the test not conducted according to the railroad's own operating rules, such alleged bucket tests to be an improper reason for certification. Alright, the ID of the 50641, 50641, this issue such concerning the Railroad Safety Advisory Committee working with a group on Part 240, reaching the consensus of the FRA, publishing the interpretation in the rule which the FRA adopted, promulgating Section 240, Part 117, F3 in the 1999 final rule ID 50636. Not deterred despite the numerous reiterations by the FRA of the Part 240, but it intended to be strictly limited to the railroad industry continued size and cultivated every opportunity to instead wield in its acts. As the result, the FRA recently implemented the third major amendment to the regulation during the brief lifespan. See Title 74 Federal Registration 68173 through 68185, December 23, 2009. The Federal Railroad relied upon Part 240 with the cardinal sins and basis for the defining revocable offenses proposed in Part 242. The predictable for the cardinal sins revocation in Part 242, the violations of the Railroad Operating Rule practice in Title 49 CFR 241 17E, the emphasis added even after several major revisions in Part 240 in response to the industry abuse that continues to become a persistent flow of the disputes at various levels of Part 240. The dispute resolution process, the reflection of the tension between the specific regulatory requirement and a corresponding railroad rule that is more stringent, notwithstanding the most recent amendment to Part 240, will fully expect the railroad manufacturer new scheme to remove the locomotive engineer from performing the certified services, defining the action to hiding the cracks and regulation. Although proposed scope of the provision in Part 242 and consistent with the more FRA regulations prior to ongoing experience with the minimum standards established with the scope and frequently result in inconsistent application of unintended consequences and has consequently produced applications plainly contrary to the FRA intent. The railroad has relied upon gaps in the regulatory language to invent new ways to deny the work opportunities and the employee to create economic consequences for undesirable employees by the manufacturing schemes to avoid compliance with the collective bargaining agreement requirements exceeding with the clear regulatory limitations written in the rule. The FRA has effectively encouraged the continuation of the model by permitting the railroad to implement even stricter guidelines by Viva operating rules proposed to Statute 242.1. For the example state, the part does not restrict the railroad for adopting and enforcing additional more stringent requirements consistent with this part, Title 75, Federal Registration at 69197. The FRA has regularly revisited the seemingly clear regulatory language of Part 240 as the regulatory history implied demonstrates. Although the FRA has rapidly shown the willingness to address agency's regulations to correct the railroad abuse for the time lapse between the identified abuse and unintended consequences, addressing it into significant harm in individuals without providing them with any means of the redress situation that preceded an amendment to the rule before becoming effective. The body counts have been permitted to accumulate while awaiting the regulatory correction of the abuse is intolerable. The minimum standard approach has caused significant problems with locomotive engineer covered by Part 240. Therefore, is no individual advantage of adopting the same concept for certified conductors. Clearly, the scope of the provision in Part 240 is out of balance unless the FRA has acted decisively. Conductors regulated by Part 242 will suffer the same fate. Labor attempted to persuade the FRA to implement a uniform standard for the Railroad Safety Advisory Committee rule-making process. The FRA dismissed the law labor concerns in favor of the railroad assurance that they would be responsible. Labor is unaware of the FRA's reluctancy to limit the railroad unimpeded right to implement their own rules. That is unlike the FRA, which will use its authority and institute uniform standards. Given the history, it is inevitable some of the railroads will explore new ways to design conductors' work opportunities, rely upon regulations to shield them from the economic consequences for their actions as they have the administrative with the Part 240. In this regard, the FRA is more familiar with its industry two-step dance and whether they argues before the disciplinary arbitration boards that back pay cannot be awarded with revocation periods while making assertions in the parallel 240 dispute resolution process. The FRA lacks the authority in order to pack the railroad revocation denial certification is reversed. It is unreasonable to expect the railroad will act differently administered in Part 242. This is our view with respect to minimum standards and set forth with the purpose and scope section reflect the 2-decade-long experience of locomotive engineering certification. The FRA recently overhauled the Part 240 with a third time in the response to the industry abuse. The FRA continues to provide with such discretion of the railroads that should not accept the different results for the implementation of this rule. The FRA cannot ignore the fact that the railroads are unwilling to restrain their certification programs administratively from evading the regulatory purposes to create unintended consequences for their employees. Since the FRA is unwilling to constrain the railroads by implementing a uniform rule, we propose the several changes to proposed regulation are unwarranted accordingly with the urge for the FRA to require the railroads to 1. Identify the program required by the Part 242.101 Appendix B of this part where they intend to adopt enforce an additional more stringent requirements for the conductors, and when the railroad implement new additional more stringent requirements, the FRA must consider the material modifications to program process the new requirement through the procedure outlined approval process. The term material modifications also must be defined by the FRA. We recognize that it is most difficult to write the definition encompassing the broad concept but given the fact the FRA will often revisit this rule, the FRA will have the ample opportunity to refine the definitions. Given the long implementation period of 1 year of the January 1st, 2012, along with the railroad industry's 20-plus center experience in locomotive engineering certification, with the FRA correctly stated in the preamble, can easily be identified that Title 75 Federal Registration 69172 is unreasonable to expect the railroad to identify those areas where each of the railroad will implement an additional more stringent requirements for the conductors. Statute 242:17 definitions. Ineligible and ineligibility for the other terms. Ineligible and ineligibility are defined in Part 240 with the use of the terms and identify the periods of the time locomotive engineers rendered unemployed by the railroads. Application regulation is which is established by Part 240 with the relevant employee, which is termed to describe the unemployment status. And discussion in 242:111 prior safety conductor that is a motor vehicle operator. The FRA recognizes the inherent unfairness of the structure Part 240 with the yet proposed extent that the injustice for the conductor will be covered by Part 240 for the FRA concluded as a matter of the fairness, the railroad should not revoke, deny, otherwise make the personal ineligible certification until the person has received the due process from the state agency taking the action against the motor vehicle license. Otherwise, the action pursuant to this part might be deemed premature, since the American judicial system is based on the concept of the person being innocent until proven guilty. Title 75, Federal Registration 69174 is equally fundamental and unfair with the FRA to require the economical consequences of suspensions be triggered prior to any determination culpability being made. It is practicable in the expiration. The FRA considers itself powerless to require the railroad to pay back wages when the revocation decision is overturned, while at the same time requiring certification suspension to take place before the process afforded. We contend that it is an illegitimate reason to impose the suspension prior to the employee being provided with the due process that alleged for the violation deemed with a willful violation, or otherwise the suspension serves as no useful purpose. The notation someone will go right out and inadvertently come to an additional cardinal sins and preposterous. As noted, we have experienced significant difficulty in acquiring back wages for the employees who have the certification wrongfully revoked. The dispute with the arbitral means for the remedies have been negotiated with collective bargaining agreements. The problem is compounded by the fact that there is no regulatory remedy for the economic loss, including the either revocation or dispute resolution process. The result, the reality of the suspension certification prior to the individual being provided with due the process creates a level of potential economic liability for the railroad that drives it to find fault regardless of the genuine culpability. The FRA uses the phrase for the matter of the fairness preamble to identify the legal concept of the innocent until proven, given the basis of American judicial system that declines to require the due process and order on rule prior to requiring economical consequences imposed by the FRA. By the rule, the FRA uses the term legally disqualified definition ineligible and ineligibility. The use of this term disqualified implies that the person was previously qualified. Therefore, the definition ineligibility and ineligibility logically contemplate that the employee has been afforded the due process rights contained in subpart E. The definition, by very nature, is absolute. The use of the term may insert the degree of ambiguity that not institute a definition proper. Proposed definition of Section 242:17 for the ineligibility defines the period of the ineligibility may end, but the silent is on when it begins. The definition of ineligible and ineligibility should be at the very least state that that period of ineligibility may only be for after the individual has afforded due process. Section 242:109E, the proposed rule of the FRA affords the conductor the opportunity to defend themselves from the railroad allegations prior to imposition of economical consequence for the relevant in Part 242:109E states that the opportunity comment should be afforded with the person prior to the railroad rendering eligibility decision based on the information. Alright, see Title 75, Federal Registration 69201. The basic concept of the due process should include every provision that could result in the period of ineligibility for the conductors that are covered by the rule. Rather than inserting such language in each of the sections, we believe the definition of ineligibility and eligibility should be amended to address the issue. Accordingly, we urge the FRA to amend the definition of ineligible and ineligibility as follows. Ineligible and ineligibility means the person is legally disqualified from serving the certified conductor. The current covers a number of circumstances in which the person may not serve as the current certified conductor, and then strike through A period ineligibility shall begin only after the person has afforded the applicable due to the process established by the statute 242-109E, 242-115F, and subpart E may cross through or shall end while the conditions contained therein are met. For example, the person meets the condition to serve the conductor following an alcohol drug violation pursuant to statute 242-115. Medical examiner. The definition of medical examiner should be amended. The medical examiner is a medical professional. The FRA should insist that they recognize the duty of the make the insist and inform the evaluation to the extent of the employee subject to the rule. Accordingly, we recommend that the definition be amended as follows. Medical examiner means the proper person licensed to the doctor of medicine or the doctor of osteopathy. Osteopathy medical examiner will qualified full-time salary employee of the railroad. Qualified participant will contract the railroad on a fee for the service of the other basis of the qualified participation designed by the railroad to perform functions in connection with the medical evaluation of employees. As using this rule, the medical examiner owns the duty of the employee by the railroad to make an honest, full, informed evaluation of the condition of the employee. Substance abuse professional. Definition of substance abuse professional also should be amended. The FRA should insist that the substance abuse professional is a medical professional, although should not be only charged with protecting the public interest profits of the railroad, but should be to reflect the goals of successfully treating the patients. Accordingly, we recommend the definition amended as follows. Substance abuse professional means a person who meets the qualification of substance abuse professional as provided by the Part 40 with the title is used in the rule that the substance abuse professional owes the duty of the employee and railroad to make the honest and fully informed evaluation considered as a issue in progress employee. In addition, the FRA should include the civil penalty of Appendix A with the medical examiner, the substance abuse professional that does not make an honest evaluation of the condition progressive of the employee. Moreover, the medical examiner, the substance abuse professional who doesn't make the honest evaluation committed with the willful violation of the rule should be subjected to individual liability for the increased penalties such as the willful violation. All right, 242. 9. Waiver. The Federal accurately confined with the Title 49, Part 211 successfully addressed the issue. Moreover, the Federal Railroad Safety Act provided with the statutory right individuals covered by this regulation request that the waiver is considered granted with the warranted and see Title 49 U.S. Standard Code 20103D 20103G. Remove the provisions would have no practical effect of the application of the rule. However, the conveniently lay people such as the covered with the rule probably do not have the ready knowledge access to the reference to the U.S. Code with the Title 49 CFR Part 211. All right, Subpart B. Program eligibility requirements. As noted by the FRA that has relied on Locomotive Engineering Certification Rule Part 240 as the base of the proposed Conductor Certification Rules of Part 242. The general statement of the Subpart B with the section analysis of the FRA and concluded with it as with Part 240, this proposed rules afford the railroad considerable discretion. Daily administration of the certification program Title 75 Federal Registration 69171 emphasized that of the serious misstatement of the Part 240 history because of the FRA published with the final rule governing Locomotive Engineering Certification 1991, and made it plainly stated the railroad will have limited authority to deny revoke person certification. C6 Title 56 Federal Registration 28229 June 19, 1991 emphasized and added the Part 240 provides the only limited authority for the railroad's preamble for this rule should be consistent with the Locomotive Engineering Certification Rule state with the railroads will limited authority to deny revoke person certification as well as to do otherwise would invite the repetition of the problems experienced with Administrative Part 240 for the more 2 decades. See Supra. Statute 242-107. The FRA is aware of the most recent amendment of the Locomotive Engineering Certification Rule was driven abuse by the railroads. Only one carrier claim performance deficiency by reclassification trained service engineers to student engineer status and subsequent performance tests were also claimed to be found deficient. They named the certification altogether determining the locomotive engineer's employment in all cases the railroad refused according to the hearing under the Part 240 of the collective bargaining agreement and denied all other elements due to the process. ID at 080350 for the Federal Justice game the amendment of the Part 240 by the adding to Section 240-107 of the explicit states. Railroad should not reclassify certification for any type of the certified railroad and certified engineer more restrictive class for the certificate or a student engineer certificate during the person with the certification otherwise valid. We believe it is appropriate the FRA enforce the prohibition, strongly sanctioning conducting the violates the rule when maintaining the railroad to review the act of the responsibility should be the subject of the FRA imposed with the civil penalty should be levied with the administrator of the railroad certification program for violation regulations governing certified employees. We intended with a scheme such as the plaguing of administration part 240 with more of the 2 decades constituting willful violation of the regulation. The FRA should impose the civil penalties directly against the individual name of the person contact concerning the materials addressed by Section 1 of the Railroad Certification Program. Statute 242-111, labor voice concerned during the working group session of the delays in administrative of the requested information made by the state motor vehicle agencies caused by the employee to be rendered ineligible because the driving record had not been forwarded to the railroad before the expiration of the certification. The FRA partially addressed the labor concern, providing that Statute 242-111, the railroad would be required to certify the individual for the additional 60 days in the time the requested information required by the section and that otherwise met with the requirements of Part 242. However, the ineligible there will be an instance where the other no fault their own the conductor had made with the proper request of the state agency design provided information prior to the expiration of the 60-day extension. The FRA has adopted it to address the issue of Statute 242-111 for permitting the conductor for the railroad petition for the waiver of Statute 242-111B requirement. We suggest a more efficient way to handle the problem exists, which is equally effective with the purpose of reviewing the motor vehicle record, determining whether during the 36-month period prior to the railroad certification decision the candidate for certification or recertification had a conviction from a completed state action to cancel, revoke, suspend, or deny the motor vehicle driver license for either operating the motor vehicle while under the influence impaired with the alcohol-controlled substance, or refusal to undergo such testing as required in state foreign law with the law enforcement official seeks to determine whether the person is operating the vehicle while under influence of alcohol and controlled substance, Statute 242-111, and if there's been such a state action, the candidate is required to undergo substance abuse professional evaluation to determine whether the active substance abuse disorder exists to follow whether the program is required by the standard of substance abuse professional, see Statute 242-11-0. However, the FRA proposes to impose duty on the certified conductor for the candidate for the initial certification report such action within 48 hours of action with the railroad. See the title Statute 242-111-1 for the self-report. Also would trigger the substance abuse professional evaluation required by the Statute 242-111-0. This review of the state motor vehicle records intended to verify someone in compliance with Statute 242-111-1 for the regard of the anticipate the FRA schedule with the civil penalty. The final rule will include the penalty of failure to comply with Statute 242-111-1 as just part of 240 provides that such penalty when someone subjects their two faults self-reported in C Title 49 Part 240 and Appendix A. This review the state motor vehicle records that it would undergo the violation of the Statute 242-111-1 exposing the individual civil penalty further in the schedule. Alright, we would expect the application for Statute 242-111F of the Railroad Safety Board would require the notarized declaration, affidavit, some other form of the sworn statement to know that Statute 242-111N incident has occurred with the preceding 36 months of the condition precedent granting with the waiver of the petition. And if our assumption is correct, we suggest that such requirement could be written directly into the rule, thereby relieving the Railroad Safety Board with the burden of having to handle with these matters. Accordingly, we propose that Statute 242-111F be revised and read as follows. If the person requests information pursuant to paragraph H of this section is unable to obtain, this person shall submit the notarized declaration affidavit that has had no incident described in Statute 242-111 has occurred within the preceding of 36 months in order to certify. A railroad shall certify the recertified person who has submitted the notarized declaration of the affidavit if and the person otherwise eligibility requirements provided in Statute 242-109. Alright, 242-115, section of the section about analysis discusses the substance abuse disorder, alcohol, drug rules, compliance with the section rule, identifies a certain situation where the referral to evaluation by the substance abuse professional required with the preamble to specify instances, identify the rule, do not relieve the railroad of the general duty of the appropriate action with other instances, attempts to identify the indicator that may warrant the evaluation of substance abuse professional. Specifically, the FRA complains that the declining the job performance, extreme mood swings and irregularity attendance stalled, indicating the substance abuse professional evaluation. Strong belief that the guidance the FRA offered for the railroads indicate that the substance abuse professional evaluation should be removed from the preamble. Irregularity tends for the ambiguous conceivable concept. Moreover, the very nature of railroad opportunities employees is regular. Employment is irregular. The guidance set forth in preamble any railroad implementing an attendance policy that prohibits the employee from taking any time off, claiming that anyone who does such as irregular attendance and that penalizes them by requiring that a substance abuse professional evaluation. Needless to say, a few experiences with such a policy will chill anyone's desire to take off, even address the cumulative fatigue that results from the railroad's irregular work schedule. Such outcome would inconsistently with railroad safety. Extreme mood swings, totally subjective concept that have no place in regulation. In fact, the mood swings frequently can result with the harassment, intimidation, management of the irregular work-sleep cycle, premature of the industry, the stress that comes with the daily struggle the railroad employee endures for the conduct, normal family life, and event. The offensive suggests that the FRA could allow unqualified management determination regarding the constitute extreme. All railroad managers to hide behind the regulation and harass employees. Even one instance, one such harassment was encouraged by the FRA is one time too many. There will be certainly by more than one and sordid history of Part 240 has shown on numerous occasions. Declining job performance and any other subject concept that has no practical place in the rule. There is no doubt the railroad will exploit the guidance required of the individual who does not meet their increasing productivity standards to be evaluated by the substance abuse professional. Railroads are just waiting for the reason to validate the productive exemptions and will undoubtedly blame a failure to satisfy that the employee possible substance abuse inconsistable that the FRA would suggest such advice and should be removed from preamble altogether. Refusals and failures proposed in Section 242.115e that contains several references to certification consequences for an employee who refuses to fail to provide a breath or body fluid sample. The labor agrees that failure to provide a breath or bodily fluid sample should trigger the revocation consequences, as the FRA bears the legitimate medical reason that a person is unable to provide a breathe or a body fluid sample. The Title 49 CFR 40 Subpart 1 addresses the constitute refusal recognizes that there are legitimate medical conditions when an individual failure to provide with a sufficient sample is deemed as refutable. Title 49 CFR 219.104A2 requires removal of the service for refusal of the provided sample. To further the failure to provide the breather bodily fluid sample to consider refusal of the absence for the documentation medical condition that prevent the individual from providing a sample, therefore unnecessary to include the failure in the rule text or positive text results. In addition, it is to be noted in Statute 219.603 provided with the compliance for the employee may be exposed within, in the case of the documentation medical failure emergency, the rule should be amended to clarify that the person was unable to provide breath or body fluid sample for legitimate medical conditions. The emergency would consider to have the post-positive test results as follows: either prior alcohol or drug conduct federal rule compliance schedule. Consider the evaluation of Statute 219.109, 219.102. For this chapter, any refusal, striked out, or failure to provide with the breather body with the fluid sample for the testing under the requirements of Part 219 with the chapter will be instructed to do so with the railroad representative. The period ineligible described in this section determined in accordance with the following standards: refusal to provide with the breath or bodily fluid sample to testing of the requirements of Statute 219 of the chapter instructed to do so, but the railroad representative shall be treated for the purpose of ineligibility under the paragraphs in the same manner as violation. Section 219.102 of this chapter, in case of the refusal to provide with the urine specimen or sample, or Section 219.101 of the chapter, in the case of the refusal to provide with the breath sample of the Part 219 subpart D of the blood specimen, a mandatory post-accidental toxicological testing is Part 219 subpart C. We also would point out that subpart G of the FRA control alcohol drug use and regulation excuses a covered employee with the compliance with the requirement to participate in random drug testing in the case of documentation, medical, and family emergency. See Title 49 CFR 219.603. The same time true regarding the random alcohol testing. See Title 49 CFR 219.609. We understand that the reference to Part 219's proposed section in 242.115 E2 incorporated the experience of that set forth for the subpart G. We request the section and section analysis with the final rule clarify that our understanding is correct. Statute 242-117, paragraph C of the proposed section would address the issue for the House whom the learning of the deterioration of person correctable vision of the hearing and certified conductor would have notified the railroad. As preamble, the FRA noted that the concern of the state of the performance conductor certification out whether the person can notify the railroad within the set time frame. The C, Title 75, Federal Registration 69176, is not always apparent in individual movement of the hearing of the vision of the deteriorates below the standard set form of the regulation. We concern that if this is discovered, the person has been deteriorated vision, hearing, acuity with after an incident, they might be subject to unwarranted additional penalties and enforcement actions according to the statute 242-117K. Should be amended as follows. As a condition maintaining certification, each certified conductor shall notify the employing railroad medical department, or if no department exists, the appropriate railroad official if when they become aware of there be accurate visions of the hearing of the deteriorated extent, but the person no longer meets the one or more prescribed visions. Hearing the standard requirements for the section, notification is required prior to the knowing performing any subsequent services as a conductor. Statute 242-119. The FRA is aware of minimum training standards as being implemented. We believe that the training provision of the rules should be coordinated with the upcoming STAR Part 243, Section 242-119, and should not be deleted and replaced as entirely as follows. Deleted all this. Initial training should be conducted in accordance with the requirements in Part 243. 242-121. The FRA purposes of the training under the section cannot be open book testing. Many of the railroads open book testing today. We do not believe that any of the danger of the safe operating railroad will allow railroads to continue conducting with the training and the knowledge of the testing with open books. Moreover, the real world of the railroad operation, one would accept the conductor to refer that his or her written in rules and instruction whenever there is uncertainty about what is required, a particular rule, instruction, or practice. Therefore, Statute 242-121E6 should be deleted. 242-123 is stated that there is an ongoing failure to lease some of the railroads to ensure the locomotive engineer working the train surface due to the economic conditions prescribed, provided with the timely manner complying with the testing. He resisted the addressing of the problem. The labor the FRA attempted to address the issue of ruling the section 242-123, the BF, and required the railroads to conduct the operational performance compliance testing. Certified conductors who have not been retested for the calendar year return to the certified service, although the section 242-123F requires the railroad to conduct and announce compliance with the testing of 30 days from the time of the individual return. The conductor service is unclear. The individual may perform a certified conductor service until they have been tested. The FRA should address the lag time in the performance provisions in the same manner that they did with the lag time for the acquiring motor vehicle record. The rule shall be make the clear employee make work of it, and for 30 days pending the unannounced testing required by the statute 242-123F of the FRA amended the rule as follows. A certified conductor was performing the service required for the certified person on this part, but need not to give any unannounced compliance. And however, the certified conductor returns the service required certification pursuant to this part, the certified conductor shall not be deemed ineligible. Must be attested the pursuant to section 30 days of his or her return. Moreover, there is more consequence if the railroad fails to refuse the conducting testing required in Statute 242-123F. Will urge the FRA to include the civil penalty with the Appendix A with the violation. Will the violation of the provision, the penalty should be assessed with the individual name of the program and responsible for compliance with the program required with the Statute 242-101A6. Or Subpart C, Administration Certification Program, Statute 242-201, the conductor certification should be consistent with the upcoming medical standards that are being considered by the FRA. Statute 242-211, the FRA has included the requirement that the replacement certificate must be provided with the employee, not no cost to the employee. This is a fair and reasonable manner to handle this issue. We appreciate the FRA addressing it in such a conscious way. Statute 242-213, if the preamble of the FRA requires regarding the instances where the person who is serving is both a conductor and engineer, a lone engineer, the RCO, or remote control operator involved with the revocable of that, the Title 75 Federal Registration 69179, as also the FRA considerable addressing the provision and proposed with the section which required the railroad to make determination as to which certification with the revoked basis of the work of the person performed at the time of the conducting occurred. ID, if FRA noted the unusual to have the railroad make such determination cited with the Part 225 as an example, the railroad has experience making the determination. We believe this is a reasonable approach for this question. Accordingly, we support the FRA proposed that the revocation should be based on the work performed at the time of the incident. In addition, both certifications are revoked. Different lengths of time, it must be clear that the revocation period shall run concurrently with the statute 242-213. H1. The FRA uses the example of the individual who had the conductor certification revoked 3 times in less than 36-month period of twice an infraction of Statute 21899. Once the infraction of a stop signal, appendix may provides with a concise chart of the revocation period of the required under that scenario, but neither the rule of the Appendix E is clear with that the 30-day locomotive engineering certification revocation period for the violation of stop signal should be required concurrently with the beginning of 1-year conductor certification revocation period for the violation. There will be recommended in the statute 242, 213, H1 as read as follows. For the purpose of determining the period of which performance may not work, if the certified locomotive engineer due to the revocation of his or her conductor certification on violation of statute 242, 403, E1, E through E5, and or E12 will be counted with the person who holds the current conductor's locomotive engineering certificate who has had his or her conductor certification revoked 3 times in less than 36 months for the 2 violation of statute 242, 403, E6, 1 violation of statute 242, 403, E1 would have his or her conductor certification revoked for a year, but would not be permitted to work as a locomotive engineer for the first month of the revocation period and the period of the revocation for the 1 violation of statute 242, 403, E1. Subpart D, Territorial Qualification and Joint Operations, Statute 242-301. Many severe accidents, casualty, fatalities occur when the tracks designated other than main track, providing the job of the unqualified employees necessary responsible to cost-efficient method of improving the safety of the railroad industry. To determine the job broadly defined the working group to allow the railroad as many options as possible. The preamble discusses the options such as map charts and events, even to contact a person to alert the employee with the hazard condition that may exist within the territory. It may be aware of the hazards such as the permit, the temporary closure, no clearance of the condition would dramatically reduce the severe injuries and fatalities. Labor believes providing the job on no qualified employees effective as a means of addressing the FRA fundamental mission to improve the safety of the railroad industry. Furthermore, labor conditions ultimately remedy fatalities occur with the hazard to remove the hazard. The rule recognizes the railroad may not own the right of the way or one other than the main track removing the hazard may not be within the authority, or they may claim it at the cost of prohibitive since because the railroad cannot remove the hazard should not relieve the railroad from doing everything in the proper mitigation of the danger provided with the job as such as the minimal cost that the railroad should not be relieved the requirement simply because it's inconvenient. No employee should be jeopardized the life of the health and because it is not practical for the railroad to inform them of hazards. Therefore, we urge the FRA to amend the statute 242-301D as follows. If the conductor lacks territorial qualification other than the main track physical characteristics required paragraph A of the section when practical, he or she shall be assisted by a person with a certified conductor meets the territorial qualification requirements for the other main track physical characteristics were not practical for the conductor be provided as a job aid prior to the entire track entering the track. Subpart E, Denial and Revocation Certification. Again, the FRA relied heavily on the Title 49, Part 240 for the development of subpart labor that intends the useful consideration of existing locomotive in the revocation process discussed as how it failed much of the debate and disagreement with the working group center agreement around the treatment of the evidence, potential evidence on the property to handling the investigation and hearing the revocation process. Labor maintains on properly handling rules, disclosure, discover the evidence, the statute 242-307 and proportional skewed against the employees who have been in charge with an infraction of the FRA requirements in statute 241-117E. The FRA should not carry out over the procedural insufficient as if the conductors governed in part 242-401. The preamble states the FRA welcomes comments whether the intervening with the cause of exemption, paragraph D, but should be modified, including the recertification requirements and additional revocable events of statute 242-403. For example, the paragraph could be modified to read as follows: the railroad should not determine the person failed to meet the eligible requirements for this part, shall not be denied the person's certification. Sufficient evidence exists for the establishment of the intervening cause preventing with the material impaired with the quality and ability to comply with the railroad operating with the rule of the practice certification recertification requirements performed on basis denied by the person's certification recertification. Title 75 Federal Registration number 69181. We agree that the statute 242-401 should be modified. D should be also be modified. Noted that above delays are procuring with the state motor vehicle driver information that they are fault within neither individual nor the railroad. The FRA has proposed the main means of dealing with such delays, which have suggested amending the slightly see supra. Not every intervening cause of the card impact the certification recertification determinations can be anticipated, nor can the rule be written off one size fits all fashion according to the revising the provision the FRA suggests would be the fair way to address such problems. Statute 242-403, the preamble explains the criteria of revocation of the conductor certification we derived with Statute 241-17 and 240-305. Likewise, 242-403 would make the unlawful conductors violate any of the 12 precepts identified in paragraph E of this section. This being said, that the discussion constitutes appropriate action for the term used within paragraph C2 by the conductor prevent employee from the monitoring, instruction, and the piloting from the committing of the infraction should be revised to make it clear that the conductor's duty is filled by warning the potential foreseeable violation that they should be held culpable. To do so, we recommend the FAA revise the preamble discussion to reflect the following. As explained in the paragraph C2, the appropriate action does not mean that the supervisor pilot instruction must prevent the violation from occurring at all at cost, rather than the duty shall be deemed to meet the warning, then conductor engineering appropriate with the potential foreseeable violation. See Title 75, Regional Registration 69181, for more of the title statute 242-403 C2, 240, and 242-403 E2-1. The proposed rule should be amended to reflect the conclusion follows. Statute 242-403 C2, the certified conductor monitoring piloting instruction conductor fails to take appropriate action preventing the violation. Paragraph E of this section shall have his or her certification revoked. Appropriate action does not mean that the means of the supervisor pilot instruction must prevent the violation occurring at all costs. The duty is met by warning the conductor of the engineering as appropriate potential foreseeable violation. Statute 242-403 E2-1. When the conductor is located with the operating cab, the speed at which the train was operating exceeds the maximum authorized limit by at least 10 miles per hour. When this respective of the speed, the fact that the railroad should be considered only those violation conditional clause of the restricted speed. The clauses that require stopping the one half of the locomotive engine or range of vision of the operational equipment equivalent thereof, which caused the reportable accident incident under paragraph 295 of the chapter, except the accident incidents that are classified and covered data under statute 225 F5 of the chapter. The appropriate action does not mean the conductor must prevent a violation occurring at all costs. The duty is met by the warning the engineer potential foreseeable violation. Electronic devices. The FRA also seeks to make comments for whether the violation of final rule of the Title 49 CFR Part 220 with the restriction of the railroad operating employees using cellular, telephones, or other electronic devices should constitute a revocable event with the conductor, locomotive engineers. Title 75 Federal Registration 9182 during the development of Part 222, the FRA asked for the comments about the question of labor that remains opposed, including the violation of Part 220 for the revocable events of the Part 240 and 242. We also understand the railroad supports the notion of the violation of 220, which should constitute the revocable event with the Part 242. However, the review of the railroad comments of Part 220 should not let the reason for the belief of the inclusion of the appropriate, except for the thing that they should be a good idea to have additional means of the imposing economical hardship on certain employees that have to cover the FRA regulation for doing so, without diminishing the tragic consequences that have also ensued the improper use of the proper personal electronic devices with implicated data with the presented with the FRA leading up to the implementation of Part 220 of the simplified do not support the inclusion according to the FRA original. 5 cardinal sins on Part 240 of the designated that have the revocation consequence because of the implicated with a significant portion, more than 5,000 of the 6,990 train accidents between 1977 and 1987, in which the 20 most common engineer-related human factors errors were caused. The Title 65 Federal Registration 28235, June 19, 1991. However, the FRA experience with the emergency order of the number 26, Executive Order 26, was far different. In the period effective to the date of the October 27, 2008, to the December 7, 2009, the FRA discovered that approximately 200 instances where the order may be violated. The FRA Office of Railroad Safety recommended enforcement action against the employee of the railroad. With the 36 of the instances, all of the 36 of the action were based on the railroad employees using an electronic device failing to have the earpiece removed from the employee's car, or failing to have the device turned off in a potentially unsafe situation. Of 36 instances, approximately half of the involved employee using the failing to have the cell phone turned on while the cab locomotive during the potential hazard time. In addition, with 33 the instances, recommendation enforcement action involved individual imposing the railroad supplied devices. Title 75, Federal Registration 27674. We believe that several conclusions can be drawn by the FRA data. Clearly, both the FRA railroad sufficient rigorous programs to detect possible violation. The FRA has not hesitated to apply existing enforcement tools. The absence of an indication that any of these possible violations led to reportable accident injuries. Casualty can only mean that none of the other outcomes occurred, while they alone makes the violation qualitatively different from the outcomes of the violation of the cardinal sins. The growing number of the potential violations are identified in the FRA sheds no light whether there is a pattern sufficient with the warning imposing the draconian punishment that would result from the expansion of the Title 49 Federal Regulation 240 117E 242-403E. Numerous questions pertaining to the available data published by the notice of proposed rulemaking in part 220 have not been yet answered, such as training and testing of the Executive Order 26 to progress, we would expect for the number of the potential violations to decrease over the time. All parts for the 15 months included the person identified with the FRA of the notice of proposed rulemaking for Part 220. That period is broken down into the 3-month segment, which is trended in potential vision violations. The downtrend would indicate the compliance with increasing the current enforcement methods appropriate and effective. The percentage of potential violation occurred with Class 1 railroad with a count of 95% of the freight revenue carrying the overwhelming majority of the most hazardous cargo. The percent of the potential violations occurred in Class 2 and Class 3 railroads were usually the portable electronic sound of the train for train control purposes far more prevalent than Class 1 railroads. More because of the Executive Order 26 was in Part 220, but was applied to different smaller railroads, Class 1 railroads, including potential violation. Data Class 2 and Class 3 railroads permit railroads to provide apples to apples comparisons considering whether to expand of Title 49 CFR 240-117E or 24403E. The number of potential violations, how many of the violators were railroad, rather individual, how many remaining potential violations were committed with the employee of these railroads, considering whether to expand the scope of the Title 49 CFR 241-17 or 242-403E would be outrageous considering the employee violation occurred with the railroad, or the railroad itself is expected to having the violated Executive Order 26 because of no assurance that the railroad provided with the correct information concerning the Executive Order 26. Railroad sufficiently stressed the importance of the absolute compliance. The appropriate starting point of the reasonable consideration question in the Title 49 CFR 242-403E 240-117E should be experienced with the data and trend that exists with the respective potential violations of the Executive Order 226 Part 220. For example, employees of the Class 1 railroad themselves did not potentially violate the emergency order using existing data has been analyzed with the perspective including the statute Part 220 for the violation of the statute 222-403, eventually 241-1117E would be consequently cart before analysis of the horse. The signal aggregated with the number of the included preamble to notice proposed rulemaking for Part 220 does not provide a basis for such conclusion. It also must be noted that the FRA currently has sufficient enforcement tools at its disposal, cited with the ability to detect violation and authority to punish the individuals who believe impermissible using electronic devices and notice provision rulemaking on Part 240. Whether the reasonable belief of the accident was caused and affected by the railroad operating employee's action or omission, the FRA subpoena the employee's cell phone records or other personal records if they related to the FRA investigation. The FRA does so now. ID 27678. The FRA were to find probable violation of the final rule has occurred. The FRA conducted an attempt to take action on the individual employee by the way of the authority to impose the monetary civil penalty disqualification of the employee from sensitive safety service. ID at 27682. Alternatively, the FRA decides to forego ongoing objective analysis of utilization of the railroad accident data and adds Part 220 infractions to Title 49 CFR 242-403E. Eventually, 240-117E. The regulation must clearly state the revocation consequences that are appropriate only when electronic devices are improperly used by the employee performing safety-related duties such as improperly contributed with the event identified with the Title 49 CFR 219-201, thereby triggering mandatory post-accidental toxicological testing with alcohol, drugs, and overwhelming Majority of the operating employees would be subject to the rule of performing the duty, safety, and the integrity every day of the entire careers. However, all the human occasionally may simply forget to turn off the implied device, such as a cell phone. More besides the devices currently on the market are not equipped with a standard on-off switch. Instead, the non-use the trigger sleep mode, the device is automatically powered on upon the opening of the cover, touching the key in the screen, thereby giving the false impression of the status device. The accident incident of the FRA cited with the support issuing the emergency order 26th notice purpose of the proposed rule of the Part 220 provide the use of electronic device with the train vehicle moving the distraction circumstance to underline the cause of the train of those accidents, and the notice proposed rule making the FRA cited 7 accidents, 5 railroad accidents, 1 aviation incident, and 1 highway accident. See Title 75 Federal Registration 27673, 27674. Also, scientific data of the FRA cited the issue of the Emergency Executive Order 26, which was the foundation of Part 220, identified the performing additional tasks using cellular phone as the actual distraction condition with the increase of the risk of accidents. This considerable scientific evidence that the cell phone used both oral conversation testimonies and the increase of the rate of the highway accidents result of the driver distraction. Brown and Polton 1961, Burns, Markson, Burton, Smith, and Birch 2002, McCartan, Hengelong, Braitman 2006, Parks, Luke, and Burns, Lands 2007, Rainey 2008, Reed and Robinson 2008, driver distraction is defined in Australian Road Safety Service, TZ, Stoney, Bishop, Aaron, Harkness, Lango, and Smyrtle 2006 as follows. Driver distraction, voluntary, involuntary discretion, intention with the primary during a driving task not related, impairment of the alcohol, drugs, fatigue, medical condition. The diversion occurred between the driver performing an additional task or task temporarily focusing on the objective of the event. The person not related to the primary driving task, the diversion reduced the driver's situational awareness, decision making, and or performance, resulting in some incident, collision, near miss, corrective action, driver, and other road users. Shell 73, Federal Registration 58706, emphasis added. FRA cited no evidence merely having a cell phone turned on creates an unsafe condition, although the incident at FRA relied upon indicated the actual use of the performance and additional task while the train vehicle was moving combined with the distraction condition, not the fact that the device was in the on mode. The FRA alluded that to issue an on-off mode within the preamble of the Emergency Executive Order 2006. The FRA inspected with the frequent observer of the cell phone of the PDA within the reach of the locomotive engineers operating terrain with the device rings. The locomotive engineer rarely answered the presence of the FRA inspector, but the circumstance led the responsible person to conclude that they would answer if the FRA inspector was not present. ID 58705, the comment preamble of the executive order speculated about what would happen if the phone were able for the ring. The FRA inspector was not present. Many of the duties involved with the executive order arose with the result of discovering an employee with his cell phone turned on at the time of the operational test. Statute 242-403E, even 241-17E, that amended the add violation of the Title 49 CFR Part 220 subpart C. The amendment of the rule was based on the FRA unsubstantialized speculation. Any individual could have the certification revoked with the phone electronic device left on the ear rings and makes noise for the individual unaware of the device. Moreover, given the railroad's unbrokenable record of the concerning 240 to produce results never intended with the FRA amends Part 240 provides in Part 242, then it must be clear about the circumstances that may result the revocation consequences, especially with considering the agency and the railroad industry position. Title 49 CFR 24307 HE. H2 minimum nature accidents and with no direction potential effect for the railroad safety. It would be outrageous penalty if the individual suffered the revocation simply because he or she inadvertently left the cell phone camera on the mode when they are on duty. Because of the rule providing with the railroad the discretion decided not to bring the revocation charges against the employee of the D- incident has been interpreted or not included obligation that ever actually be applied. The FRA needed to explicitly require the reasonable application promulgating such rule as Title 49 CFR 220-305. Require the personal electronic device to be turned off to be in compliance with the rule. However, the failure to do this device turned off should not result in the revocation because there's no evidence whatsoever, meaning merely having the devices on the on mode to create a distraction and result in unsafe conditions. Whether the railroads have been taking a position that may still revoke the certification as in D- infractions occur, such as having the device turned on the no effect of the safety. Other remedies of the FRA and the railroads. All right, 242-407. The production process is subject to significant debate with the deliberation of the work group, with no doubt that the employees will ask confident that they will be afforded a fair on-property hearing with a charge with the violation of operating rules that may result with the revocation of the certification balance on property hearing with a suge's legitimate concern of labor could request the FRA strengthen the disclosure discovery requirements of the revocation process, which the railroad resisted for the claiming the local representative will have the railroads on a wild goose chases. Of course, it takes ignores the hearing of the officer authority statute 24407C6, deeming a request unduly representative so extensive lacking the relevance for that admission would impair the orderly, fairly resolution of the proceeding. Emphasis that the railroad approach for the hearing with the attitude of the employee was guilty until the proven innocent. The revocation of the hearing of the process is designed to provide the charge rather than conduct the true investigation hearing. Also, the fact that the hearing officer is always railroad official primary reason for the employee rarely feels that they have received fair and impartial hearing. Despite the fact we reached the consensus proposed rule of the Railroad Safety Administration Committee, working with the group of labor continued to believe that it entirely reasonable to require the railroads to disclose the evidence produced the witness and relied on based on making suspension decisions. We strongly urge the FRA to consider the position expanded to clarify the several aspects of the proposed rule. Alright, your labor appreciate the FRA effects of the address of the discovery concerning the section 242-407B4 of the proposed the railroad to provide with written information list of witnesses the railroad will present with a hearing provided with the recess information only provided with the just prior to the convening of the hearing. The language creates the ambiguity of the term just prior. The history of the Part 240 instructs the railroad hearing officer with inevitability viewed just prior to differently. The employees and his or her representatives will expect the hearing officer to typically deny the request for recess because of the determination whether the constitute just prior or the refusal to grant recess of the hearing with the suspension of grounds will impose yet another prejudicial burden upon the dispute process. To have any practical value, the rule must provide with some of the definite time cutoff provided with the written information written witness list of the employees the railroad are required to convey with the history required with the section within 10 days of the suspension notice, and the suspension notice must be based upon the railroad's receipt of the reliable information. It is completely reasonable to require the information railroad relies upon the reach of the suspension decision provided with the employees at least 48 hours prior to the hearing. Furthermore, the employee must be given an opportunity to evaluate the evidence of the railroad will rely upon the hearing to determine the veracity of the information additional witness and employee that shall be brought into the hearing. Further, we recognize the issue of telephonic testimony compromised by the FRA with the use of the telephonic testing and several problems that must be minimized and maintain the highest possible degree of the impartial of the fairness of the hearing. The simple way, no way, hearing officer to observe the individual testing on the other hand with the telephone to make the reasonable credibility determination, determine if he or she is being coached or even if the person he or she claims to be for a matter of the rule processes allow telephonic testimony with it. It's a practical provided with the witness at the hearing. There's no definition of what the constitutes impractical. We predict that any time the witness has something else to do, it will be deemed impractical for the presenting of the hearing. The undoubtedly result of the operating crew review board also makes a determination concerning what was constituted impractical, whether the employee suffered substantial harm because of the testimony of the witness taken telephonically. There's no sound reason for the eyewitness to the event of giving the reason arrived. The suspension should not be required to provide the live testimony as a matter of the fairness of the railroad. Unwilling to unable to provide live testimony for the witness for the event, the railroad should not be permitted to rely upon individual statements and testimony supporting revocation decision. Telephone testimony should only be permitted for the witness that will provide with the general subject matter of testimony. Therefore, Statute 242-407B4 should be amended as follows. No later than convening the hearing, notwithstanding the terms of the applicable collective bargaining agreement, the railroad convening the hearing which shall provide the person with a copy of the written information list of the witness. The railroad will present the hearing if requested. Access start of the hearing will be granted if the information on the witness list is not provided at least 48 hours prior to the schedule. Convening the hearing of the information provided with the statement the employee with the convening the railroad will make the employee available for the examination during the hearing required in paragraph B3 of the section. Examination general subject matter witness only may be telephonic where it's impractical to provide a witness at the hearing. In addition, will the example the FRA used the preamble regarding how the railroad should apply with a discretion incident with a minimal nature, but they should be clarified. The example, the 100-car freight train traveling a high-speed track on the bottom of the steep of the grade exceeds the speeding restriction of 10 miles an hour. The front of the lead unit extends the speed restriction, but by the third unit, the extension of the speed restriction of the train moving at a proper speed is unrealistic. A 100-car freight train anywhere left alone with the bottom of the steep grade will not be able to reproduce the speed by 10 miles an hour with a two-engine length. An unrealistic example such as provided no guidance determining whether incident D- instead of it suggests that D- standard cannot be satisfied, therefore be ignored. Similar to the banner text example to which the engine barely touched the main banner would be carefully constitute the minimal nature incident event with the new railroad exercise the discretion provided with the Part 240. In this regard, however, the FRA should acknowledge that any time engine touches the banner, even when the engine does run over the brake or the brake knocked down with the banner, the speed engine at the time of the engine touches the banner must be considerable, since contact of the equipment less than an authorized coupling speed of 4 miles an hour could not be produced sufficient damage to the trigger restricted speed violation in an event. And again, the example provided with the FRA portrays the D- significant error other than its objective is. Finally, the discussion of the paragraph established the FRA will consider the railroads to make the faithful determination minimal nature and incidents shall provide with the defense against civil enforcement. The acknowledgement does not nearly go far enough. We believe the FRA must provide the immune and civil enforcement. The FRA makes such good determination otherwise provided. The railroads reluctant to exercise the good faith making the determination first practice. Place discretion set forth in the rule compromise of nothing more than hollow words. A subpart F, dispute resolution procedure. Along with the locomotive engineering certification rule, the base of the dispute the resolution process proposed with the rule preamble, the FRA recounted with that early decision on the issue of the dispute. The resolution involved a significant debate over how simplify the appeal. The FRA, aware of the many of the appeals that occurred in Part 240, take years to resolve. Examples of the lengthy process needed to resolve is the proposed rule of the FRA docket number EQAL 97 through 48, 97-48, which began in 1997, not concluded with the statute 240, not concluded until 2014. The FRA Dr. EQAL 0613, which would petition to deny certification in 2005. More than 5 years later, the remains they resolved according to the FRA to consider significant simplifying dispute resolution process. Some that adopting the following changes will create more expeditious dispute may arise with the conductor certification rules. We believe the operating crew review board should be a standard size, having the person assigned with the qualified to make the determination required in statute 242.505H, I, and J. Section 242.501C should be amended as follows. The operating crew review board should compose of at least 3 employees of the Federal Railroad Administration selected by the administrator, one who shall be an attorney. Statute 242.503, proposed section 242.503B5 would require the employee to supplement a petition for the review of the written documentation in his or her person with a responsible available to him or her that the documents for railroad's revocation decision would be understand that the intent for them provided with the employee opportunity to submit relevant evidence that he or she believes may support the petition and not always apparent that the documentation required to be maintained. Is available to the employee according to the urge of the FRA as amended with the statute 242.407B4 with the indicated with the comments on this section of proposed rule. Title 49 CFR 4329 provided for the employee the right to have the testing laboratory of the MRO over the service agent release records, including the MRA note. If the employee with the information sometimes referred to the litigation pack have with the vast majority of the conductors will never be about thought, but the revocation process will not typically be in the position to know the information, or even when it exists, that they have all the right information on familiarity caused with the conductor, and consequently, failure to comply with the statute 242.503 will not include the litigation package of the documentation filed with the operating crew review board. In the case of lit involving alcohol drug tests, the FRA should add the requirement of the railroad notify the conductors written with the right to acquiring the litigation package the laboratories, the MRO, other than service agents, to disclose the conduction of the conductor on the record revocation hearings conducted in compliance with statute 242.407B4 with the charges violation of 242.403E12. The notification should contain the minimum extent language contained in Title 49 CFR 403029. 242.503 C. The FRA noted that Part 20, 240 contains a different time limit for the filing petition for the review, depending on whether the person seeking the review of the revocation decision 120 days or denial decision 180 days. In Statute 242.503C, the FRA proposed the petition seeking the review of the revocation denying service decision would have to be filled with the FRA within 120 days of the day of the decision, served with the petitioner and labor understand the support of the FRA's desire to make file requirements uniform. We do not believe that 60-day additional time filing petition review will create a burden of the FRA. Moreover, the additional time is extremely valuable to an employee who had never had their certification revoked. We look for the knowledge, experience, the swift research, applicable regulation, martial evidence, compose arguments with strongly FRA to amend the proposed rule to provide longer or two-time period change of the statute 242.503C from 120 days to 180 days. Statute 242.503 has been striked out. 242.505 for the operating review for the review of the conduct informed with the review of the petition and must have the entire record with the disposal determination what may or may not be necessary for the operating review but with the disapprove of the railroad certification decision can only be made after the review of the complete with a record of the section 242.505G and F and G will provide with the operating review with the remand of the issue in order to the according to information with the full record operating crew review with no way of knowing there whether the information testimony requesting already contained the record. This only way to ensure that there is no case that requires the review for the entire record. Section 242.505 shall be amended as follows. Within 60 days of the notification provided in the paragraph B of this section, the railroad shall submit the FRA entire record of the hearing conduct pursuant to statute 242.507. Later filings will only be considered with the extent and practicable. Or the operating crew will determine whether the denial of the revocation certification, recertification proper under the part of based on an incorrect determination of the person failed to meet the qualification requirements of Part 2 granted and deny this petition accordingly. 242.505E. As we previously stated, we continue to disagree with the minimum standard proposed for the FRA appropriate for this rule. We respect for the be strongly continue to disagree with the FRA preamble discussion regarding the purpose of the scope of the rule, which also states that the proposed rule would be not constrain the railroad's ability to prescribe additional more stringent requirements for the conductor that are not consistent with the proposed rules. Title 75 Federal Registration 69168 emphasized added. We submit that the rule cannot be simultaneously established one standard for the conduct of the employees and another standard for the conduct of the employer. Therefore, the practical procedural requirements of this part must be also considered minimal. The procedural responsibility of the railroad denying revocation, conducting certification to allow the operating crew review or discretion the determination whether the violation of procedural requirements for the subpart constitute the substantial establishment that they are indeed not minimum standard rendered for the substantial section right meaningless of the determination constitute providing the due process any process. Furthermore, the FRA approach will allow the railroad to open option to implement anything less stringent procedure for the denial revocation process. So part E of determining whether the conductor meets the minimum requirements of part, just as they have done with the impunity over the lifetime. Part 240 is the outcome of the FRA have the proposed the procedural rule of the hollow meaning. Therefore, will reiterate the strongest terms of the part 242.505I. Should be amended as follows. Standard review of the procedural issues. When considering procedural issues with the board will determine the substantial harm was caused by the petitioner virtue of the failure to adhere to the dictated procedure making the railroad decision and finding of the substantial harm of the ground reversing the railroad decision to establish the grounds upon the board may grant the relief. Petitioner must show the procedural error occurred with the procedural error caused by the substantial harm or violation any of the requirements of this part per se constitutes substantial harm. Standard review of the legal issues should be clarified and clearly either party. Legal interpretation question review the operating crew review. The rule should be reflected. The operating crew review will consider all the legal interpretation correct. With the statute 242.505J should be amended as follows. Standard review of the legal issues pursuant to the reviewing role of the board will be considered whether the legal interpretations are corrected by de novo review. Section 242.505K. In Section 242.505K, the FRA stated will not consider whether the railroad properly implied with the more stringent requirements we believe the essential integrity of the rule itself, having the Operating Crew Review Board consider whether the railroad consistently applied with the more stringent requirements other than the FRA effectively would permit the railroad to apply the different standards of the different people left behind with the regulation to allow the very disparate treatment. The FRA acknowledgement in 1989 has repeated without and without the responsibility of the authority of the Operation Crew Review Board could be rendered consequential of the decision whether one person would have their certification revoked the more stringent requirement while another person who commits exact same infraction, exact same location, are the same with the circumstances may not without the Operating Crew Review Board authority to consider consequences. Consistent application of the railroad must be stringent requirements for railroad free of the continuing to apply with the FRA regulations partially. The rule should be amended so that it is clear that the Operating Crew Review will not consider whether the railroad properly applied with the more stringent procedural requirements. The Operating Crew Review will consider whether the railroad is consistently applied with the more stringent rules that impose the ineligibility consequences period required by this rule. Section 242.505K should be amended as follows. The board will determine whether denial, revocation, certification, recertification, proper use under the regulation based on the incorrect determination the person failed to meet the certification requirements of the regulation grant and deny the person. Accordingly, the board will consider whether the railroad has consistently applied the more stringent requirements, but they will not otherwise considered. 1. The priority railroad more stringent requirements, or 2. Whether the requirements were properly applied to its own more stringent procedural requirements. Section 242.505L. Operating Crew Review written decision must include the explanation of how to which the determination, therefore, that Statute 242.505 should be amended as follows. The board written decision shall be served with the petition, include the petitioner review, if any, of the railroad. The decision will include the finding of the facts that it was based on. As we stated above, the most of the dispute with appeal beyond the LERB with his decision of Locomotive Engineering Certification Rule with the Title 49 CFR Part 240 to take the year to resolve. The process should be simplified. The railroad conduct with a fairly impartial hearing with accordance with the Subpart E with the review of the Operating Crew Review Board. Should there be a sufficient to address the arguments that either the party may have, there may be proposed new section incorporated within this to the rule of follows. 242.505, the decision of the Operating Crew Reviewer constitutes final agency action. The request for the conduct hearing should likewise be simplified and expedited as much as possible. The revocation hearing conducting in accordance with the Subpart E, the statute 242.501 through 242.505 are modified with amendments accorded and forth with a de novo review of the case. The redundant delay, the dispute therefore recommended as follows modification of the proposed rule. 242.507. Either the petitioner before the board of the railroad involved may seek the administrative proceeding and prescribed in the statute 242.509, and the Operating Crew Review Board shall have the sole discretion whether to conduct a hearing. Any hearing may be limited to the Operating Crew Review Board to issue any that deems appropriately necessary to be determined in the matter. And then B's all scratched out, C's all scratched out, D's all scratched out, 1D1 scratched out, 2 scratched out, 3 scratched out, EB. Upon receipt of the hearing request, the Operating Crew Board shall arrange the appointment of the presiding officer who shall schedule the hearing of the earliest practical date. 242.509. The presiding officer conveying the presiding over the hearing shall be defined the relevant facts to determine the correct application of this part to those facts. The presiding officer may be authorized to discover the type of the quantities of the presiding officer's discretion with the contributing of the prior hearing unduly burdening the party. The presiding officer may impose the improper inappropriate sanctions in accordance with the provision of federal rules of civil procedure, including the limitation of the presentation of the evidence issued with any of the parties with the failure of the refuse to comply with the approved discovery request. Whenever the party has the right to require to take action with the period prescribed by this part of the law, regulation directive with the presiding officer presiding with may extend with such period without notice, God cover provided with another party with a substantial prejudice, such as the extension request the extend with the period with the already expired with may be denied as untimely. Discovery shall be conducted in accordance with the procedure set forth in the Federal Rules of Civil Procedure. O. The proceeding officer shall comply with the Federal Rules of Evidence in the United States Correspondent Magistrate. The General Guidelines and Introduction of Evidence, notwithstanding paragraph M of the section, all relevant probative evidence shall be received unless the presiding officer determines the evidence for unduly repetitive is expensive and lacking the relevancy that admission would impair properly on orderly fair resolution of proceeding. P. The presiding officer may 1. Administrative oath and affirmations. 2. Issue subpoenas provided in the statute 209 7 in its part 209 of this chapter. Adopt the need of procedural submission evidence in the written form. Examine the witness for the hearing. Convey the recess adjourning, otherwise regulated with the course of the hearing. Take any other action authorized with the consistent provisions of the part permitted with the law that may be expected by the hearing aid of the disposition of the proceeding. Q. The petitioner before and the railroad involved in the taking the certification shall be the parties may participate in hearing and may appear to be heard on that behalf of the designated representatives. All parties may offer the relevant evidence, including testimony, may conduct such cross-examination. Witnesses may be required to make the record of the relevant facts. R. The parties seeking resolution of issuing of the shall have the burden of proof of preponderance of the evidence. And then the rest of that scratched out. At the close of the record, presiding officer shall prepare written record of decision to the operating crew of order and proceedings. The decision one shall contain the finding of the fact conclusions as well as the basis for concerning all material issues, the fact laws. The record shall be observed on all to the proceedings. Is not precedential. 245.11. A party may file an appeal for the operating crew or file a decision presented to administrative office. Well, that's struck through. Alright, Appendix A should be several penalties not persistently included in Part 240. Appendix A, Statute 242-107C, reclassifying otherwise valid certification 5,242-1115 F1I, failure to make honest evaluation 10,242-123 for F, failure to conduct test 9,500, 13,000. We would like to thank the FRA for the opportunity to comment on the proposed rule, specifically submitted by the Dennis R. Pierce, North National President of the Brotherhood of Locomotive Engineer, Bertrand Hood, and Mike Furthery, International President, UTU, United Transportation Union.